And this amendment bill, Mr. President, also secondly gives us cause to look closely at how we select judges, particularly, and to look at the intention and the ambition of having us use a selection process that allows enough judges with the right expertise who are committed to giving adequate time to the job and to performing at a level that enables efficient, timely, and fair processing of cases. The Supreme Court of Judicature Amendment Bill proposes adjustments in the above interests, which, by extension, will contribute to the continuous improvement of the administration of justice in this country. Specifically, this bill proposes to increase the number of judges in the High Court, to transform the selection process going forward with the establishment of a Judicial Appointments Committee. It seeks to establish a commercial division of the High Court and to address related matters. On the matter of increasing the number of judges of the Supreme Court, the Principal Act, the Supreme Court of Judicature Act, Capt. 117A, it stipulates that the High Court of Barbados shall consist of a Chief Justice and no more than 8 judges of the High Court. This proposed amendment seeks to raise by 5 the number of permanent posts in the High Court bench, moving from 8 to a total of 13 High Court judges. So why raise the number of High Court judges, Mr. President? The backlog that we are looking at of cases are anywhere between 10 to 15,000. And we need additional resources to manage that backlog. A second reason why is that annually around 2,000 new cases are being filed every year. And we cannot expect 8 judges in the High Court to realistically handle the backlog as well as the cases being filed. And in terms of the speed of justice, which is another reason why we would seek to increase the number of judges in the High Court, is that some cases are taking so long, so very long, that the lawyers as well as the accused persons are no longer able to speak with certainty as to when the trial will be held, when they will get a hearing, and when a decision will be made. And it has contributed to bail having been given to persons because they cannot determine with certainty when the trial will come. And they want to make sure that they're not infringing on anyone's rights by extraordinarily long periods of time being held in jail. And for more than 15 years, not since 2003, has there been an increase in the number of judges in the High Court. And so it brings us to the second reason. Why change the selection process for judges? In the past, Mr. President, the Prime Minister held the power to recommend appointment of judges to the Governor General upon consultation with the Leader of the Opposition. I believe it's Section 81 of the Constitution that speaks to that. Now, the constitutional arrangement is not being altered. But what we are seeking to change is the method by which the judges are chosen. The intention is to choose judges on merit through a competitive process with a wider applicant pool. so that we have persons in the profession who are no longer left to wonder, Mr. President, whether there was favoritism or discrimination, where they don't have to ask the question, well, what happened that so-and-so was made a judge? Where there are persons in the profession who do not have to accuse of undue personal influence being used in the appointment of judges when they're asked, well, who pulled the string for so-and-so to get a pick? And it is important that there be equal opportunity. Now, all of these have plagued the judge selection process in Barbados for a long time. And while we do not purport to make all determined complainers of this happy, Mr. President, I would say that Barbados is in good company when we seek to change the way in which we select our judges. And I say in good company because there is the Latimer House Principles, which is developed by the Commonwealth, about 15 countries across the world, where which speaks to the separation of powers of the three main organs of government, of a democratic government: the executive, the legislature, and the judiciary. And it speaks of the independence of the judiciary, these principles. And if I may quote from those principles and rules, Mr. President, it says that an independent, impartial, honest, and competent judiciary is integral to the upholding the rule of law, engendering public confidence, and dispensing justice. Further goes on to say that to secure these aims, judicial appointments should be made on the basis of clearly defined criteria and by publicly declared process, and that the process must ensure equal opportunity for all who are eligible for judicial office, appointment by merit as opposed to any other means, and that the appropriate consideration is given to the need for progressive attainment of gender equity and the removal of other historic factors of discrimination. And it is with these principles at the front that the government of Barbados, through the fine work of the Attorney General and the Prime Minister, that we are seeking to make adjustments to the process of selecting judges. And one significant change in that process is the appointment of a Judicial Appointments Committee. That is one of the amendments proposed in this bill. The intention is to remove some of the power which now sits with the Prime Minister to appoint judges and provide a more transparent process that engages others who are experts in the field and who are best able to contribute that expertise in selecting suitable judges. In the proposed fourth schedule to this bill, the composition of the Judicial Appointments Committee is laid out. And if I may again, Mr. President, just share that with this Honorable House. Made up of the Chief Justice ex officio, at least one person who is a former Justice of the Court, at least one person who is a former Chief Justice or a former Justice of Appeal, one former judge of the High Court, one member of civil society, and that is the people, one attorney at law with at least 10 years standing, who is also a member of the Barbados Bar Association. And so you see that the intention is for this Judicial Appointments Committee to be made up of people with integrity, with the reputation, and with the capacity to truly be able to discharge the work of that committee, which will include, among other things, vetting applicants, supervising and managing the advertising and the interviewing processes for judges. So unlike before, the post of judge will be advertised, as has not been the case before. The Judicial Appointments Committee would also make recommendations to the Prime Minister on persons who are suitable for appointment. So it is not up to the discretion of the Prime Minister alone in consultation with the opposition leader. Applicants will not only be Barbadians. The intention is that the process be thrown wide open to the rest of the Commonwealth. And that has been in the practice whereby we understand that in order to get the best minds, we must look at home for those best minds, and we must look far and wide as well. And Mr. President, the advertisement of posts cannot be done just anyhow. This bill also stipulates in very exact terms how that advertisement has to be done. And in Schedule 4 under the Powers of Judicial Appointments Committee 7, it says that there must be some advertisement in the Official Gazette, at least one local newspaper, writing to the Bar Association, and by electronic means to the rest of the world, especially the Commonwealth. And when this committee does its work, it will meet only when it has business to be done, meaning when there is a vacancy to be filled. And it will report at the end of the year to the Prime Minister, reporting not only on the matters relating to the business of the committee, but also on any problems. And this bill suggests, in fact, mandates, that the Prime Minister must bring that report and lay it in Parliament for all to see. So there is transparency, Mr. President. Nothing is hidden. One other amendment proposed by this bill is a separate division of commercial courts in the High Court. Increasingly over the years, more complex commercial transactions have led to increasingly complex litigation. And this kind of litigation requires specialized knowledge. And when this litigation must go through the civil court, as it has been wont to do, it is not uncommon that judges are unfamiliar with the subject matter. They take a little bit longer, and it becomes more expensive, more costly to litigate. The business community has been calling for a specialized court for commercial matters for a very long time, Mr. President. And we are on our way there in listening to the constituents who use these courts. Before, Mr. President, in the High Court, There was a civil division, there was a criminal division, and there was a family division. There will now be that fourth division, which is the commercial division. And the jurisdiction of that commercial court, if I may, Mr. President, in the first schedule, Part 2, it lays out what would be the responsibility or what will fall within the purview of that court, including, and I will not read all, sir, but just to give the public a general understanding. Business documents or contracts, exports or imports of goods, cases related to the carriage of goods by land, sea, air, or pipeline, the exploitation of oil and gas reserves and other natural resources, insurance and reinsurance cases, banking and financial services cases, the operation of markets and exchanges, the purchase and sale of goods, of commodities, arbitration, among other things. And so we can see, Mr. President, that the intention to have 3 specialist judges assigned to the commercial court will go some way in easing some of the load in the High Court at this time, which normally these kinds of cases may go through the civil courts. And the intention of deployment of judges is that there'll be 4 specializing in civil cases, 2 more added to the criminal division, which will bring that to a total of 4 specializing in criminal cases, 3 assigned to the commercial division, and 2 in the family division of the court.
3, 5, and 2 is 7, and 4, 11.
4 for civil.
4 civil, 4 criminal, 3 commercial,
3 commercial,
and 2 family.
I think that might be 11.
No.
Well, it's 13.
That's 13.
4 and 2 is 7, 3, and 10. Yes,
That's
I'm sorry, 13.
Sorry to interrupt.
No problem. It is recognized, Mr. President, that when you have more judges, you will need more space and there will be more logistical type of support that will need to be provided. This government is well aware, and the Attorney General and this government as a whole is committed to putting the necessary resources in place to support the effective implementation of this new dispensation.
I know every stage people work. The system right
Mr. President, when our justice system is slow, the fallout affects all of us. It frustrates the efforts to fight corruption and other crime because culprits get emboldened when, by not feeling any swift consequence to their actions, they're allowed to go. It also becomes expensive and unaffordable for ordinary Barbadians who have to pursue cases indefinitely when the wheels of justice are turning slowly. And sometimes their pockets run out of money long before their spirits have died. There are many other disadvantages of a slow justice system, but I will not lag and linger on that now, Mr. President. What I will say is that the proposed amendments that are captured in the Supreme Court of Judicature Amendment Bill is one more deliberate step by this government to rebalance the scales of justice in the interests of more efficient, timely, and fair justice in the system for all. And it is with those few words, Mr. President, that I beg to move that this bill be read a second time.
The question is that this bill be now read a second time. I recognize Senator Franklin.
Thank you very much, Mr. President. This afternoon, I want to say that this is a glorious day in the history of this Parliament. You know, who's to say that the Barbados Labour Party don't honor its promises? This bill is the partial fulfillment of a promise made to the people of this country in 1974. In 1974. Sir, you will be well aware, sir, you were in those elections, that, no, I'm saying, you remember, that in 1974, the Constitution was amended to remove the power of appointing judges from the commission, Judicial and Legal Service Commission, to the Prime Minister in consultation with the Leader of the Opposition. I was a boy at school then, and I used to follow politics all back then. And I recall the leader of the Barbados Labour Party, the senator's father, marching a band of people to Government House. They say, and one of the things they said was they will repeal those amendments when they get power. So that's why I said it is partial fulfillment of the promise made by the Barbados. So they're keeping their promises, but this is a promise made in 1974. Sir, and what has happened since that amendment? When the Prime Minister has reason to advise the Governor General on the appointment of a judge, the Prime Minister decides who that judge will be and consult with the Leader of the Opposition. Consult doesn't mean agree. And consultation doesn't have a particular form. It could be the Prime Minister come to that conclusion and people over the balcony and say, hey, opposition leader, are you going to appoint so-and-so to be judge? And he'll shut back and say, I don't agree. He said, I don't care. And fellow is a judge. That is answer. We have had a long history since 1974 of people becoming judges, and a lot of people question them. Myself have questioned one or two since I became an adult and saw the caliber of the person that I...
With what effect?
Well, but no effect whatsoever, because the Prime Minister had the say. So even though I usually complain about bills coming to Parliament at such short notice. So the procedure that we use by suspending the standing orders is for emergencies. And this is such an emergency. The courts have almost ground to a halt. They're barely functioning. And people blame the lawyers because the lawyers seek an adjournment, and they blame the judges. I put the blame squarely on the judges. I can tell you why. This court has rules. The court has rules. And an adjournment is not automatic. If the lawyers are dilly-dallying, the judge can say, well, look, no more adjournments. The rule says so we can move to hear this case on a particular date. But the judges are only too happy when the lawyers are not ready or not ready for adjournments. All they have to do is to penalize the lawyers for being tardy, make them pay a cost, and not the clients pay the cost, make them pay a cost, and you will see that the system will be speeded up. That's one way of speeding it up. While I support the amendment, And I agree that we have to get these judges. I think what we should be working toward is getting less criminals. You know? But right now, to get less criminals, you can't legislate that. And you can't embolden them, because we had criminals here at the opening of Parliament. So they were emboldened. Yeah, criminals were here invited to the opening of Parliament. You know, so they were emboldened. And that's probably why there's such criminal activity going on in the place now, because they believe that they have backing. I'm sad to say, sir, but that I'm no sociologist and all kind of stuff like that, but that's one thing that I'm not, sir. Sorry. I'm not a sociologist, but I have formed the conclusion that these people get emboldened because of the associations they have with certain political people in this country. I could be wrong, but I doubt it. Right? But I will not belabor that point. I think it is made, and I will go on from there. Yeah? I want to touch on the delays in the system. I started already by saying that the judges are solely responsible for them. They run the courts, not the lawyers.
Point of order, Mr. President. Referring
the standing orders, Mr. President. 34, contents of speeches. 8, the conduct of the Governor General or officer administering the government. Members of either House, judges of the Supreme Court shall not be raised except upon a substantive motion moved for the purpose of.
In anticipation of that, I had asked before my standing orders whether they don't provide for against attacking judges. Yes, I was for the first time without mine, and judges of the Supreme Court, I'm attracting your attention to 34.8 of the standing orders of the Senate of Barbados. Reference shall not be made to any matter which is sub judice in such a way as might, in the opinion of the chair, prejudice the interest of the parties thereto. And then they go on, again the governing words are reference shall not be made. The conduct of the Governor General or officer administering the government, members of either house, judges of the Supreme Court of Judicature, shall not be raised except upon a substantive motion moved for the purpose.
Sir, I'm guided by you, but I probably misunderstood that. I thought we were talking about individual judges. So when I was speaking about the judges as a collective, because I was saying...
It might be worse when you're not dealing with one but all.
You know, I said that, but my misinterpretation. I'm guided by you, sir.
They're only 8, so you know who they are.
Yeah, because, look, sir, I can speak to delays, because, let me start to speak to the delays then, sir. My union commission...
It's a matter of how you formulate it,
yes.
too.
Yes, I will try my best, sir. You know, I'm not the most eloquent.
I'm sure you can find your way around that.
I will try my best. I'm not the most eloquent that you are well aware, but I will try my best. My union commissioned a lawyer to bring a matter before the High Court for one of our members. The case started in 2010. December 2010, I think it was. No, sorry, it was September. And we got a decision from the judge in December 2010. 6 months later, the order was not signed. The draft order was not signed by the judge. 6 months. It forced me to write the Chief Justice to complain that the judge was being tardy. Within a day after that letter, the order was signed, and we got the order and was able to serve it on the other side. Then after, that's 2010, for 3 years, the other side did not obey the court order, and we filed for an assessment of damages and contempt of the parties, of contempt of court. That matter was set down for September 18th, 2014, and then the other side sprang to their feet on September 20, 2017 to ask the court to set aside the judgment 3 years after. 3 years after the order was made, or the judgment was made. And the courts entertained them. But the court entertained the application to set aside after 3 years. It went before a judge, and the judge said, in February 2nd now, the following year, that, sorry, February 3rd, according to my note, that the judge might have to recuse themselves because of some conflict that they perceive. But they will discuss it with the Chief Justice before doing so. That was February 3rd, 2015. On December 21st, I get vexed now because the judge hasn't decided if they're going to recuse themselves or not. And they hadn't spoken to the Chief Justice so far. I wrote the Chief Justice again. That judge summoned the lawyer to court and my member and had some words, given some words. And she said, I'm going to recuse myself. And furthermore, Mr. Franklin is a witness in another case, and I'm going to recuse myself from that too. Because I had made, I wasn't a party to anything. And so that is the level of pettiness that we had in the system. Delay. That case started in 2010. To date, sir, to date, we are still at, after we had the 3 year, 2010, 3 years down the road, I know we want the judgment set aside. And but we have not heard, we are waiting for now to get that matter done, but the interlocutory matters pending. So all it now, the case is finished. That is delay. And it is delay not on the part of the attorneys or whatever. It is solely at the court thing. The courts are not functioning. They're not following their own rules. Because I've seen the rules of the court, and they set time limits, they set things. Yes, you might not be able to meet those limits at any one time, because they're not set in stone, but at least you should observe them. And you're waiting years to get matters done. That is unfortunate, sir. And it is also unfortunate to victimize me, because I complained that justice was not being done. I do not know if the appointment of these 5 judges will make it any better, that they will come in and fall into line, or that the existing judges now would see what is happening with these new high flyers and pull up their socks. We are hoping that they are pulled along, the existing judges are pulled along by the people who are coming in. Because, sir, it is dangerous. I filed a case against the Attorney General when the present Prime Minister was Attorney General. I'm yet to see a judge. I'm yet to see a judge. Pardon, sir? No, sir. I don't blame the Prime Minister unduly, only when it is when I think it is necessary. And she had she was out of office for 10 years. And so she couldn't have any influence on my case not being heard, or me not seeing a judge. And to be fair, sir, part of the delay was due to my lawyer, but not all, and not the substantial part of it. See, I'm being fair. As the system currently exists, sir, the Prime Minister, as I was saying earlier, the Prime Minister makes a recommendation, and whether the leader of the opposition like it or not, and we've had instances where the leader of the opposition objected, and the Prime Minister said, well, this is my man, and he went on. I will not call any names, but it is well known around the place when that happened, and who it happened for. This system now is an improvement. The system proposed in this bill for the Judicial Appointments Committee is a far better system than what we have existing, but it should be better. My concern, sir, is that the Prime Minister makes the appointment, makes the recommendation to the Governor General. This committee will advise the Prime Minister who she should make. There's nothing in here that says that the Prime Minister must accept the recommendation. Do you know that? I read it a couple of times. I know in the public service, when they set up interviewing panels, that panel, I don't mean public service proper, when they set up interviewing panels on the Public Service Act, the authority, the commission, can say no and send it back to have the interviews done all over. And they set up a system, a 1, 2, 3 system. Let's say you have one person, you want one job, one person, but you have several people applying. So they recommend person A to get the job, and then B and C will be ranked 1 and 2. Within the 2-year period, if there's another vacancy, or Lord forbid, number A dies, or something happens, then number 2 gets the job without any further interviews. 2-year period. That happens in the public service. There is no similar provision in this legislation, and I think that that is a shortcoming of this one, because let's say you interviewed some people to fill these 5 posts now, but you had a whole set of people, and they were good candidates, but you can't employ all. And a vacancy occurs within a short time after those interviews. Are you going to offer the job to the next person in line, or are you going to activate the system all over again? Some of those people, and because all of them might not be living in Barbados, to meet and go through the process that they went through a couple of weeks or a couple of months before. I think that is a shortcoming. I think that should be addressed. Now, 2 years in the Public Service Act, but this one determines it. We can determine what a short period is for this legislation. So that is only one of my concerns. But the Prime Minister, as I said, whoever the Prime Minister is responsible for appointing this committee. And that is where I have a difficulty with the separation of powers that we're talking about, the Latimer House thing. The Prime Minister is ultimately responsible for picking the people who will pick the judge. I think that is a job that should be in the hands of the Governor General. You know, I'm not saying anything disparaging about the Governor General, so please. I'm only saying that role, that should not be a political function. The Governor General should be the person who appoint this Judicial Appointments Committee and take away because the Prime Minister has the role of picking them and then accepting their recommendation, or, as the case may be, not accepting the recommendation because the act does not speak, the amendment does not speak to what happens if the Prime Minister doesn't like. Could the Prime Minister say, I do not agree, and then decide, well, look, I still have the power to appoint, or power to make the recommendation to the Governor General in consultation with the Leader of the Opposition. That needs to be clarified. As I said, I'm happy that we are having some progress. But the progress that we're having, sir, is a baby step. What we need, what we need to make bold steps and to put the appointment of judges beyond any question, you know. And let me go on to say this, sir, that I do not believe that it should only be for judges. This Judicial Appointments Committee should be responsible for appointing magistrates as well. Because if memory serves me correctly, you have to be an attorney at law with 5 years standing to be a magistrate. And they have put some people in place, and sometimes I worry about the decisions that they make. Just a couple of weeks ago, and I have it here on my I think I wanted to write about it, and I was waiting for the newspaper to retract what it said. It said that a bailer gets bail. In Barbados today, it's coming up. I'm not going to call any names, sir. This person went before the court to stand bail for someone. And the magistrate agreed, okay, you're a good person to sign the bail. But the following week, that same bailer turned up in court, charged with something, and the magistrate said that she was disappointed in the person. The person pleaded not guilty. The person said, I am not guilty, ma'am. And the magistrate goes on to say, I'm disappointed in you. Now what happens there is that the magistrate has already convicted that person, because that person says, you're innocent until proven guilty. But the magistrate, and this was in the Barbados today of the 14th of January, 2019. And I was looking to see if they had made a mistake and that the magistrate would complain and that they'd have to retract. But there was no retraction. You cannot, or sorry, you should not prejudge a matter. And this...
On a point of order, Mr. President, I'm sorry. I don't mean to interrupt my colleague, but if we're talking about legislation and he wants to support or say that we need to improve, that's one thing. But he's stepping into the realm of bashing judicial officers, both judges and magistrates. And the thing about it is that you can identify who he's referring to, because he's named the newspaper, he's named the circumstances. That is not fair, because that person cannot come here and defend themselves. So I would ask that Mr. Sorry, well, in this case, that Senator Franklin control what he is doing in here this afternoon as it relates to the judicial officers of our country. Moreover, he is confirming that the report was accurate without knowing the facts. He is getting on like he was present, which I doubt he was. And most importantly, he doesn't know if there was a retraction or not, because there are occasions when you can have a retraction that does not make the newspaper for whatever reason. I'm not here to defend anybody in particular, but in dealing with judicial officers. You have identified the person without calling the person's name. I would ask that he shows some restraint as he goes on to make the point that he thinks that magistrates should be appointed a certain way. Develop that point. Stop bashing our judicial officers. I'm much obliged, sir.
Sir, I'm not bashing anybody, and the rules say I can't bash judges. I'm talking about magistrates. But in any event, right? But, sir, I'm not trying to bash anybody. I am pointing out that the quality, what I'm reading in the newspaper, I'm saying that something like this should not happen. And that we need, since we need, people are asking for a higher quality and better trained judges and stuff. I'm also asking...
With all due respect, on a point of order, Mr. President, he's misleading the House because he can't speak to the quality of anything without knowing all the facts. The person of whom he is speaking is not here. He does not know all the facts, Mr. President. He is misleading the House in terms of talking about quality and so on. It is not reasonable and it is not fair.
Sir, all I'm saying, sir, is that based on this story in the paper, I said yes, you're right, I was not there, but there was no retraction. I read this since the 14th of January, and I read the paper every day. Contribute significantly regularly too. But there's been no retraction. And I'm saying, if that is the case, we should be having those trained minds who will be selecting judges also to select the magistrates. Because magistrates do more of the criminal work in Barbados than any judge, you know. And I've seen situations where a magistrate said to a person, and I was present, that he's going to, the person applied for bail, and the magistrate said, I'm giving you a bail, I'm going to teach you a lesson. That is not the role of bail, that is certainly not the role of a magistrate. If the person qualified for bail, there should have been no, I teach you a lesson. You know, that has happened. That has happened in my practice in the court. You know, you don't deny bail because you want to give the fellow a shock and let's see what it does look like and hope he mend his ways. That is not the role of a judicial officer. But it happens, and I've seen it happen. So I hope there's no objection to me that I didn't see it because I was present in the court. I have been, the thing is, years ago I was on the Liquor License Authority for District D. And when the cases were being heard, even the cases with family matters, because I was justice, I was allowed to stay in the court. And I saw some things that bothered me. And I'm saying, sir, that if the government is going to go the way of a judge, it's not only the judges, you need it for everybody who's going to be dispensing justice in this country. They should be trained. And I believe, sir, that when you have a magistrate, the magistrate should be some person who is matured, whether know the law or not, because that was always a requirement to be a magistrate, you know. Remember, we had the magistrates, and they still have some in Guyana, and they do good work. They do minor things that take away the heavy lifting from the trained lawyers. So my concern, sir, as I said, is I made a note here. It says, what happens if the Prime Minister does not accept the recommendations? Yes. If the Prime Minister does not accept the recommendations, that was one, and two, I think the committee should be, its mandate should be expanded. I'll finish with those points, and I would like to move on to something else. The problem here, sir, in Barbados, is that we try to do everything on the cheap. You know, justice is not cheap. just like representation of the people shouldn't be cheap. But we want to pay as little as possible, so you're not going to get the best qualified and the persons who, in your profession, sir, we have lawyers who make, and they're good lawyers, but they will not accept a position of a judge because it will reduce their income by 90%. So we need, sir, I'm not calling your name, sir, but people are pointing at you, and, I think that's unfair to you. But you have people who are at the private bar who would make good judges, but they can't work for the kind of money that you're paying a judge. Some years ago, there was a regrading and a reclassification exercise in the public service. And the permanent secretaries who managed that process was able to convince the government that they should be paid more than judges. Mind you, several of the people who were judges came from the public service, and they were at permanent secretary level before they became a judge. So they got promoted and appointed at a higher level and was paid commensurately. When the government of the day then accepted the advice from the permanent secretaries, it ended up with those people who were at permanent secretary level, they should have stayed where they were because they would get more money. I had to make representation because judges were part of the union. I was, at the time, it was NUPW, and we had judges as members, so they called upon us, and we made representation, and we were wrongly abused, but they fixed it. But they didn't fix it with any great amount of money. I think judges should be paid better, and then we expect them to work for the money that we pay them. They are not, the people think, oh yeah, they get a Mercedes and they get a Bentley, but it is not fantastic in terms of what a well-trained and good lawyer like yourself, sir, can earn if they are working in the private sector. So we need to look at the remuneration of judges, because you are not going to attract qualified people from the Commonwealth and from anywhere else if you pay them at these ridiculous rates that you're paying for judges in Barbados. You're simply not going to get them. When you advertise and you see that the salary for a judge is X, if you're going to say this in Barbados making sport. So that is one of the things that you have to look at. These things sound good, but you have to consider that people are not going to leave their lucrative practices to come to Barbados, relocate their families here, if you're going to bring people from outside, as you said, that can happen. If you are going to pay them the kind of money that we are presently offering judges. Judges are not opposition senators and independent senators who work for chicken feed. And government senators who are not ministers or parliamentary secretaries. I stand corrected. People see me on the street and tell me, you got a big pick, no, you got some money. And come to me to get some. Poor folks don't realize that they don't pay us anything. But you can get this work done cheaply because all of us in here have other jobs. But you're not going to get people whose only job, because you can't have a judge working as judge and then for the evening go and work at something else and then find himself in trouble. So you have to pay him well. You have to pay him so that he wouldn't have any incentive to look for other means of support. you know. And so I think Senator McConnell should take my message to the government that, yes, I wish them well in these proceedings, what they're trying to do, but they are not going to achieve what they want if they continue to pay. A former minister in the Barbados, they probably said, if you pay peanuts, you can get monkeys. You're paying peanuts. And the judges in Barbados, even though people say bash them, their work, people say that they don't work because the judge might turn up at 9 o'clock and finish at 2 or 1. But the judge has to read that file, has to do research. So all of that is being done when they are not in the courtroom. So your courtroom work is not the full, that's all that you do. That's not your full job. You still have to go there and do some other work. So yes, they have other work to do. They have too many cases to thing, and that is why I am happy that you're bringing these amendments. But we have to make sure that these amendments don't fall to naught. The last administration had reason to appoint a Chief Justice. And they amended this act and changed the qualifications for the person who hold office, or who eventually would have gotten the office. This is a far cry from what the last administration did. I did not like that. I didn't like what they did. This, as I said, I'm not going to fault the government for this. It's just that if I were doing it, I would do it differently. But this is not a bad step. It is not something that I will come down and lambast the government for, right? They are trying. But sometimes you might have a perspective. And if you don't have some person to say, well, you know something, you can do it differently, you can do it this way, you would believe that this is the best. And the thrust of my presentation today is that there can be other things. Like, for instance, I'll give an example. You have, in this thing, you're going to have a family division and a commercial division. I welcome the commercial division, and I like the idea of a family division, but the family division should be dealing exclusively with family matters and should not leave some of it to magistrates. Because what I don't like is we still have this mentality that there's some people who are, you know, the old days we had bastards and unlawful. That, thankfully, was eliminated in 1980 by the Barbados Party administration. But the courts continue to function as though they're still bastards in this land. If you are married and there's a separation and you had children, the High Court decides how those children will be taken care of. If you were involved and living with the person for 5 years or more, the High Court deals with that. Same children, you got children, the maintenance is dealt with by the High Court. But then, people who have these other relationships, some of them might have not gotten to the 5-year thing, so they don't go to the High Court, or there might be just a relationship that something happened. But those same children their fates are dealt with in the magistrate's court. So it bothers me. And then I see people standing up outside the magistrate's court waiting for hours, sir, to get access to the money that the father would have deposited to the court if he deposited at all, because I'm going to wait for hours and then hear that the man ain't put on the money. I understand that they are trying to work on that and to try to make it more user-friendly, but I feel we got a lot of judges now, and we can take away some of the burden of the magistrates in this regard and assign these cases, whatever amendments that are necessary, to the High Court. Well, why, well, you said there are only 2 judges, but why we have children? Why should one set of children be treated differently than the others? That's my concern, you know? And the way that they are treated, you know? We don't have any bastards and Barbados anymore, but the system still treat them as though they're bastards. The bastards used to go to the magistrate's court. But even though we abolished bastards, we still have the system where those people who would have been bastards back then still continue to the magistrate's court. So one of the note that I have here is, I said, unmarried parents or who were not living together for 5 years or more. These people should also be part of this, should be able to go to the family division. And what they should do is to make the procedure a lot less onerous. I remember some time ago, I was checking some Canadian system where if there was a divorce, a non-contentious matter, you fill out the form. You want a lawyer, you fill out the form, and the matters go before the judge. Lawyers, some people don't want, unless there was some property settlement or something. You didn't have to go and draft all these fancy documents where you need an attorney at law. So the same thing can happen here. You fill out some sort of form to say who you believe the father is and that he's not been supporting the child or whatever, and you don't have to go through all of that rigmarole, if you can call it that, that obtains in the High Court, and get these matters dealt with more humanely. Mr. President, I'm hoping, sir, that the government realizes that I am not in opposition to this bill and that they will take on board some of the suggestions that I made. I understand the urgency, because if you do not do it now, you cannot provide in the estimates for judges where there is no substantive position there. The estimates can only, when you allocate money in the estimates, it will be for positions that exist. If they do not exist, you won't be able to get it done unless you do a supplementary something down the road. So I understand the urgency of this matter, and I could even commend the government for bringing it. As I said, my only concern is that in that area is that it didn't go far enough, and I've made some suggestions where I thought the matter has not been, you know. I'm not saying that the legislation is bad or it is great. I'm just saying that it could be improved. With those few words, sir, I'm much obliged to you.
Thank you, Mr. President. Sir, in reviewing the proposed legislation, there are 4 stated objects and reasons. Firstly being to increase the number of judges in the High Court. The second one being for the establishment of a Judicial Appointments Committee. Thirdly, for the establishment of a commercial division of the High Court. And then there is the addendum for related matters. And I am pleased to see the proposal by the government, and very mindful of the trying times in which the country finds itself. I'm reminded of a story that in a previous cabinet in the 80s, and this of course is a story I was told, in a previous cabinet sometime in the 80s, there was a conversation being held about the need for improved judiciary and the amount of resources that should be pumped towards this angle so as to increase the efficiency. And after the presentation was laid out, the head of the then cabinet turned to someone at his side and said, "How many houses can we build for that money?" Recognizing the needs that justice plays, I think, is an important aspect of any governmental decision, and the balancing act that government has to do in providing the basic needs such as housing as well as other utilities. I think this proposal takes the importance of justice up to that level as one of the needs which the Barbadian people deserve to have attended to sooner rather than later. An increase in judges is definitely warranted for the simple fact that the current caseload on the existing judiciary is huge. Judges have a case list, those of us who receive them every Friday, well, maybe Monday in some cases, and an observation will show that most judges carry 10 to 15 cases every day. And after dealing with those cases and the attendant arguments put forward by members such as Senator Tate and Senator Sands, my arguments are normally brief, sir. They are expected to make decisions on all 15 matters with the attendant legal thorny problems they prescribed, resolve those issues, and then prepare for the next 15 that are coming the following day. The simple fact is that the situation is quite unfair in terms of the load that is being placed on the shoulders. And as set out by Senator McConney earlier, there are approximately 2,000 cases filed yearly. So it continues to increase. Indeed, it is interesting as a practitioner when you consider the amount of time it takes to prepare for a court hearing. Well, if you take any time at all, and you try to put together coherent arguments to allow some persuasion to the judge who you're appearing before. And when you multiply that time by 2,000 cases, you begin to get an idea as to the weight of the backlog, and the fact is that something needs to be done. Thank you, Deputy President. So this is certainly a good start with regard to an increase in the number of judges to take to the battle to do justice in this country. However, we can't simply rest there. More needs to be done because the new judges will simply run into the existing problems and the backlog of 10 to 15,000 cases are not going anywhere. So what, of course, this represents, we would assume, and as hinted at by Senator McConney, is that this is part of the process and part of the arsenal which will be unleashed to see an improvement in the justice system. Now, there is, of course, the need for funding for the judicial assistance for these new judges. Given the fact that the registry has been affected by the economic sanctions imposed to date, sorry, I shouldn't use the term sanctions, by the economic cuts that have been imposed to date, the government will certainly have an interesting task of finding the necessary resources to support the new judges, and support in the sense to allow them to make a meaningful impact on the load which they will face. But that is a job which I'm sure the government side is well aware of and will be using their best efforts to find a solution. And what are these tools that we're talking about to assist these new judges in moving forward? Firstly, we have to look at an increase in the number of judicial assistants. There are currently only 6. If we're going to have 13 judges, we're going to need more judicial assistants to assist the judges in their research for the cases that they have to attend to. An increased use of the technology to make cases run faster. There was a pilot project for e-filing, which would certainly make the process a lot quicker and would result in a reduction in those instances Mr. Senator Franklin speaks about where the files go missing. The use of technology and the training in the attendant technology will certainly go a long way in increasing the performance of any new or existing judicial officers. The registry has been hard hit by the cuts as mentioned and will need to be fully resourced in order to fulfill the supporting filing obligation and managing of the court load that will be placed on the judges. Long story short, this is a first step out of many, but it certainly is a step in the right direction. Now, it will be inequitable not to, of course, mention the frustration which the public feels at the pace at which matters move through the judicial system. I think as a practitioner, all of us recognize that justice moves slowly, but thank God that it moves. And it is hoped that the proposed increase of judges, along with the other attendant measures I have briefly hinted at, will go a long way towards resolving these concerns. The fact of the matter is, Mr. Deputy President, legislative changes alone won't fix the problem, but it's certainly a component in getting us to the better place. The second objective as set out under the bill, sir, is the establishment of a Judicial Appointments Committee. And this is certainly a useful initiative. Now, I heard Senator Franklin at length speak to how it could be made better and to push us to true independence, et cetera, et cetera. But the fact is, the methodology for establishing the appointment of judges is set out in the Constitution as Section 81. And the Constitution expressly says that the Governor General appoints judges on the recommendation of the Prime Minister after consultation with the Leader of the Opposition. That's what we have as our Constitution, and that is what every Prime Minister has adhered to. So the fact that the government is taking the proactive step of creating a JAC, let me be the first to use the acronym in this House, a JAC, certainly, again, shows an attempt of approaching and getting the input of others to assist the Prime Minister and adding some, well, not quite crystal clear, some little clarity or insight into the process. And certainly, since the Constitution says this is something which is within the Prime Minister's remit, any form of guidance and openly declaration as to how that guidance is to be achieved should be commended. Now, over time, suggestions could be made as to persons who should also be on this committee. Suggestions could also be made with regard to its independence. But in light of the Constitution as it currently stands, I think it is a very reasonable initiative and is something that should lend transparency a bit towards the aim or the criteria of the judges who would be appointed. And we should take a moment to recognize the fact that judiciary in Barbados has had an excellent record in terms of its service to the country, and all the talk about separation of powers and the appointment of prime ministers, I don't think there's anyone in good conscience who could question the independence of our judiciary. I believe it's something that they guard jealously, and at the end of the day, that says a lot, sir. Thank you, Mr. President. So the fact is, Mr. President, the appointment of judges is within the remit of the Prime Minister, as set out clearly within the Constitution. We have an excellent track record of judicial officers strenuously defending their independence, and the appointment of the JAC, to me, is a step in the right direction, which could be further expanded if the cries for more independent input are even heeded. But it certainly is something that should be commended with regard to the government's objectives. Finally, sir, the appointment of a commercial division on commercial judges. And this is something which is particularly close to home given the practice, sir. Senator Grant referred to his bread and butter being tourism. My bread and butter is the practice of law, or as I call it, the practice of justice. And the appointment of a commercial judges, sir, certainly is something which I believe all legal practitioners have been clamoring for a while. But I think it should also be said that the judges which we currently have commercial experience. So this concept that we need to bring commercial judges, yes, there is some truth in it, but the aim is that after you establish the commercial court, by sitting in a commercial court for a number of years, and by refining the type of matters that are brought within the commercial court, that is when the expertise of both the judges and the practitioners who are in that court dealing with these commercial matters every day, that's how it elevates, sir. So it's not necessarily that we don't have the expertise within the current stable, dare I say, or the current grouping, sir, but it's by the consistent exposure. And I believe the Senator Maynard, I'm sure there's a medical equivalent concept where the more you practice surgery in a certain area, the more specialized you become within that area. The same thing applies to the commercial practice, sir. So the benefit is, though, and it is hopeful that this would lead to a decrease in the time required to resolve commercial matters. This then lends support to investors, who simply put, sir, if they have no confidence in the ability of the courts to resolve their disputes, will not invest within the country. That's the long and short of it. If I am a commercial investor, if I'm a conglomerate and I'm lending money locally, and I know I'm going to face a rigorous uphill battle to utilize the court system to recover that money, I am not going to lend the money. And we have seen that in the transactions where we work, given the nature of the questions put forward when it comes time to doing due diligence. And it shouldn't be thought that this commercial court would be only limited to banks, conglomerates, or others. But the simple fact is the ordinary citizen will benefit as well, because these courts deal with commerce, so money is lent, business disputes. And the simple fact is you increase the access of persons to these courts to deal with commercial problems. Because if you can't get justice in the court, you're going to look for justice elsewhere. And that is something we need to be mindful of when we have this debate. So in conclusion, Mr. President, this is a bill I support. I believe it is a step in the right direction. While not a total fix, it is a component of getting it right and getting the justice system optimized within the country, and it should certainly be encouraged. And we certainly, sir, look forward to seeing the results. Thank you, sir. That is my contribution.
Thank you, Mr. President. Mr. President, we cannot, as a country, continue to say to Barbadians because of our financial incapacity, we can do very little to tackle the backlog of 15,000 cases in our courts. Yes, money is short, but sir, citizens should never be allowed to think that our judicial system has collapsed. And that our court system does not function. 12 to 15,000 backlog cases, that's too many, sir. And so, sir, this amendment that we're speaking about this evening is too urgent. It is too important, and it has to be done today. We have put certain things on our front burner. We have listed certain things as being mission critical. I think that this is one of those areas that we should do something about, and do it now. Yes, we are a broke government, but I consider this to be a wonderful initiative on the part of the Barbados government, and I welcome the opportunity to say a few words on this issue. Sir, these 5 appointments will not solve all of our problems in the court. 5 more working courts, sir, will not solve all of the problems in the court system. I'm sure, sir, that you will recall the days when there were 4 judges. When I first started to practice, we had 4. And then, sir, there used to be 6. So we've added judges before. This is not the first time we're adding judges on. And when we added those on before, we thought we would have solved the problem. But those additions did not solve the problem. There are still other matters we have to deal with if we want to see any kind of improvement whatsoever in our justice system. I have always wondered about the fact that judges have to sit, listen to the evidence, but more than that, they have to write down every single word in what we'll call longhand. And you're always hearing them saying to witnesses things like, would you repeat that again for me? Or you're speaking too quickly, and so on. I think that that's part of our system is archaic. There are machines, but still, in spite of the machines, the judges take that evidence in longhand. I don't think that that is a job for the judges. I think the judges should be concentrating on the witnesses' expression. I think the judges should be concentrating on the case itself. I am happy to hear, too, that they would be given the necessary personnel to get the courts moving. I do not believe, sir, that I should go to court in the morning and learn that the court is not functioning because this particular court has no clerk, or this particular court has no marshal available. I know one is called to say. So it is not only the judges, it is the support staff which is needed for the court to function. I want to take the opportunity, sir, to commend the present Attorney General, whose apparent ambition is to ensure that the courts in Barbados work. We are moving from 8 judges to 13. And they're now giving us, perhaps for the first time in a long time, we were calling for this about 5 years ago, what we would consider to be a full complement of judges. What else is there which would cause this type of backlog? Let's face reality, sir. Litigation in Barbados has increased. Our society has become a much more litigious society. We are more competitive. We are more argumentative. We are more aware of our rights. Things which would not have come to court before are before the court now. People who were involved in accidents on my school bus years ago, I never knew that because of the backache they had a right to compensation for personal injury. They know now. People are more aware of their work, of their rights, and therefore they take these matters to the court. And I remember the way in which the courts operated when I first joined the bar. I remember the days of Sir William Douglas. He was the Chief Justice. There was Justice Husbands, Justice Williams, Justice Worrell. Those were the 4. And you argued before them. You argued your case. And they actually gave you a specific date, some 3 weeks hence. And they would tell you, come back for your decision on April the 3rd. And you go into that court on April the 3rd, 3 weeks after. And that decision is given. I even had a situation where a decision was given the same day in the court. But they would tell you, come back and you would get your decision. Well, if you thought it was a bad decision, obviously you appealed it. But the point is that the decision was given. As I said, to be fair to the present judges, there's more litigation now. There's more work, there's more stress. But this is the price we pay for progress in our society, I guess. Because there are more cars on the road, and therefore there are more accidents on the road. And therefore there are more matters involving personal injury and accidents before our law courts. And to some extent, I blame some insurance companies in this island for not making really valiant efforts to settle some of these matters out of court. There are so many motor vehicle accidents which could be, and personal injury matters, which could be settled out of courts, but which insurance companies do everything to delay. It's not the court in that instance. To me, it's the insurance companies. I'm not going to leave out some of my Barbadian brothers either, because I can tell you that there are many Barbadians, Mr. President, like me and you, who feel that they must have their day in court. Some of them have matters, and they believe that if you do not put their matter before the court, they are cheated. They feel that you are treating their matter as though it is not a serious matter. It is my view that some of these matters presently before the court can be settled in a flash by a meeting out of court. I must also say, sir, that, well, if I was a judge, I know that whenever that case is finished on that particular day, I would put pen to paper and start to write my decision that same day. I would not allow the weekend, for sure, to pass unless I write something. When it is fresh in my mind. Exactly, sir. When it's fresh in my mind. That would be my strategy, sir. You cannot have a situation where a case is heard 4 years ago and up to now a single word has not been put on paper. The very day that case finished, when you remember the arguments of the counsel, both sides, something should be done. It might not be the exact or the entire judgment, but at least it puts you there that when you're finished, you can put the legalese and you can do your authorities and whatever else you want to do. But certainly, if you go to a lecture at a university and you're a student in the class and they lecture to you, you do not wait until 3 weeks after to go and make notes about the lecture. You do it on the spot. Because if you want it when it's fresh, you can refer to it later on. And I believe that some of the judges need to use this technique. As soon as it is finished, put something down on paper. Yes. You know, sir, one of the things that you must always keep saying, a case is not finished until the decision is given. You cannot tell your client the case finished, only decision I'm waiting on now. Because you'll be telling him so for 4 or 5 years. And the other thing, sir, is that obviously, as Senator Franklin alluded to it, if the cases are not heard at all, there's going to be more backlog in the system. Backlog does not only arise from judges not rating decisions. Backlog also arises by adjournment after adjournment, because you're not going anywhere. The case is still there, unheard. And a lot of lawyers, let's face it, I'm a lawyer, and I know it. Lawyers are not ready. Lawyers seek adjournment after adjournment after adjournment. Sometimes they call you working against them and tell you, when you go to court, ask for an adjournment, I'm not feeling well this morning. So they contribute too. Sorry, not they, we contribute too to the backlog in the courts. We can't put all the blame on the judges. You know, I've known of cases. I had two of them only. Well, one last year and one early this year. 2 clients of mine who have died. And they had matters that were put before the court some 6 or 7 years ago. And they've died now without their case ever being heard. Delays can be devastating to clients, Mr. President. Can be devastating to them. I have one client who came into my office maybe a week or so before Christmas. And he had a matter in which he was badly injured in an accident. And I could see from the way he was talking that he was not well. And he said, look, you better go and see. And I called the doctor's name. I said, you can call the doctor. Send him over. Send him to the... I took up my own few sets that I had. So, okay, you go on to the doctor. And because his health has deteriorated so badly. And the doctor examined him, called and said he needed some psychological assistance, some help, yes. And the part that hurt me really was when he said it is his personal injury settlement that is on his mind. That what the old people call the studiation of the personal injury settlement, not getting it settled, not knowing what is going to happen to him, that weighed heavily on his mind. And he said if he doesn't get some kind of word about it, he's going to be worse. So these delays in the court have some social implications, so impact on people. But you know, it also has impact, strange enough, to me. The most devastating thing is to divorcees. Waiting for property settlements by the court. You have a situation where the parties are divorced, but they do not yet know whether I am to get 60% of the house, the value, or whether you are to get 40 or 70, 30, or whatever it is. They do not know. So they are inside the house, 2 divorcees, waiting for the settlement. They're not talking to one another. Any communication is done through the child or through the children. Tell daddy so and so, tell mommy so. They don't talk to one another at all. And it is so uncomfortable. One party may very well have a new partner, but you know the new partner can't step in the house. Because you know that rule done laid down already, nothing here. And you know they share the same stove. And you know sometimes they even share the same bathroom. But if we think about the kind of social devastation which these delays can bring about, we, I'm sure, would more appreciate the need for us to do something about this backlog. Mr. President, I see someone is trying to catch your eye, sir. I see someone is trying to catch your eye. The amendment also highlights a commercial section which is to be brought on board. I have no problem whatsoever with that commercial section. But I have always said, though, that my real, if I had to put money between a particular section, believe it or not, it would be the family law section. It would be the family law section. I would have thrown resources at family law. Look, If you look at the case list any morning you will look at that case list, 75% of what is happening in the court, family. 75% is family law. I would throw another judge, yeah, in the family law area. But as I said, yes, I know how much pressure, and not only that, ask the judges about the backlog that they have and the cases. It wouldn't surprise me if, on average, each judge has about 3 or 5 property settlement in these same divorce matters in the family law area. A lot of family law and a lot of divorces. But I don't want to, if I had to continue to speak, Mr. President, about this, I would be here until about 11 o'clock tonight. But Mr. President, no, Mr. President, I would think that to date, in spite of the way we choose our judges and in spite of the way that that system gets criticized, I think that to date, we have made excellent choices as judges. I think so. I doubt that there's a lawyer in town who would disagree with that statement. Not even Senator Lawyer Franklin. Not even Senator Franklin. I think, sir, that our judges are extremely competent. They're very able. They're very bright. We have a very bright bench. That's the truth. Even those persons who in recent times have been acting as temporary judges, they have surpassed our expectations. I have heard lawyers comment on some persons who are acting as judges, and they were so full of praise of them. So even those who were in the temporary positions were doing a good job. Where the independent panel is concerned, the Judicial Appointments Committee, I know that there are people who may and who have, you heard it just now, who have questioned the selection of persons to the panel. But that's Barbados for you. That will happen. That will happen. It is not foolproof. It is not meant to be foolproof. Yes, it is a human institution and we are choosing something to make it work. But this is much more comforting than what exists at this present moment today, where a single person, a prime minister, appoints each and every judge. The vacancies, as you understand, will now be advertised even beyond Barbados. And this gives selection, I believe, some kind of transparency. This panel will not be the perfect system, but for me, it is a better system. The Prime Minister is a political figure, and many Barbadians, as we know, can only see through political lenses. And I therefore think, sir, that this panel gives us some relief from suspicion of what could have been termed political appointments. Sir, judges should be competent in all aspects of the law, or most aspects of the law, because law is such a wide-ranging thing. It's impossible to be competent in all aspects. And I think, sir, that specialization of judges is very important. Judges are like us. Judges are human. Judges have practical experience or experiences in certain areas of the law. Judges have wider and perhaps even deeper knowledge in particular subjects, more so than others. And judges, whether they believe it or not, love particular areas of the law. I remember, sir, when I did my in-service, I don't know if I should say it, but I don't think I'm saying anything. Yeah, it will date me, but I did my in-service with Sir David Simmons. And I remember going to him with a conveyance one day that was very technical. And I went to him, I said, I want some help with this conveyance here. And he put his arm to me and said, no. I don't do conveyances. I never liked them. I never liked them. As good a lawyer as he is, or perhaps one of the best ever, there are certain areas that he loved and certain areas he wouldn't touch. And I see nothing wrong if a particular judge elects to work in a particular court, whether it be family or commercial or criminal, why that judge should not be allowed to do so and to stay there. I see no reason why it shouldn't happen. In fact, the judge should be encouraged to do so. I am very pleased to support the whole idea of specialization. Civil, I understand there are 4 and 3 for criminal and 3 for commercial and 2 for family. But as I say, I don't want to continue, Mr. President, just to let you know once again that this amendment, the Supreme Court of Judicature Amendment Bill 2019, has my full support. I'm obliged, sir.
Thank you, Mr. President. I rise, sir, to support this bill. I think it's a very important bill. I cannot claim, like Senator Franklin, to be steep in the law. I do have a basic and general understanding, sir, of the law, but I'm not a practicing attorney at law at all. Nor do I allege, sir, to be an attorney at law, to be steep in the law. Sir, this debate makes me reflect on an adage. I believe that the attorneys may refer to it as a legal maxim. Justice delayed is justice denied. And I believe, sir, that Senator Greenidge did make some reference to that. Of course, what essentially that is stating is that there's an expectation of legal redress in an appropriate time, and that if that is not achieved, that it is as if it did not, it was not available for the person to whom an injustice has been done. So the bill that is before us provides for additional judges. It provides for an improvement in the system. In fact, sir, as I reflect on that legal maxim, I'm reminded of the case of Pratt & Morgan, which I refer to only to reflect the issue of the importance of time. Where I believe, sir, that the Judicial Committee of the Privy Council would have held that to have a person on remand for a period of 5 years or in excess would be on death row, sir, for a period of 5 years or more, could be undertaken as being inhumane and being cruel, sir. So that it is important in terms of ensuring that there is justice, that we facilitate the process in a very timely manner. And that is why, sir, that I am very happy today to support this piece of legislation. Of course, there's a recognition that there must be certain procedures that must be undertaken at the level of the court. There's the recognition that there are certain appeals that have to be undertaken to ensure that there's delivery of justice. But we have a situation, as Senator Greenwich would have informed, where there are too many cases that are pending in the law courts, and we therefore need to ensure that there's a speedier disposal of cases. Sir, there is specific concern I do want to make reference to in relation to gun-related activity. Of course, Mr. President, our citizens and our visitors must continue to feel safe, and we must ensure that crime does not escalate to a point where it impacts in any way on the way of life that Barbadians enjoy. I should tell you, sir, that one of our brand elements in the marketing of Barbados as a tourism destination relates to safety and security. And therefore, I think it is very important that we ensure that the necessary support is given to the Royal Barbados Police Force. Of course, Mr. President, the Barbados Hotel and Tourism Association is playing its part. I am encouraging, sir, other organizations to do likewise, because that is very important that the police force is given the resources. So you would have seen recently in the local newspapers where the BHTA would have supported the police by way of having CCTV cameras. We would have provided segways. We would have assisted in other ways, the lighting, sir, in the St. Lawrence Gap area. And we continue to collaborate with the Royal Barbados Police Force because we recognize that it is very important that we are able to continue to ensure that Barbados is a safe and secure place. We must never have a situation, Mr. President, where Barbadians and visitors are fearful about moving around in this country because of a few people who are creating challenges. And it is therefore very important that all of us give the support to the Royal Barbados Police Force. Sir, I want to make a reference to a quote from a former president of the United States, Theodore Roosevelt, and he was addressing the Minnesota State Fair. And this is what President Roosevelt had to say. The first essential of civilization is law. Anarchy is simply the handmaiden and forerunner of tyranny and despotism. Law and order enforced with justice and by strength lie at the foundations of civilization. Law must be based upon justice, else it cannot stand, and it must be enforced with resolute firmness, because weakness in enforcing it means in the end that there is no justice and no law, nothing but the rule of disorderly and unscrupulous strength. Without the habit of orderly obedience to the law, without the stern enforcement of the laws at the expense of those who defiantly resist them, there can be no possible progress, moral or material, in civilization. End of quote. Mr. President, I think that that quotation speaks properly to one of the reasons why we have this bill before this chamber, to seek to ensure that we are able, through this kind of action, to facilitate a speedier process with respect to justice and to ensure that all Barbadians are able to properly and in a timely manner have any cases which they would want heard, and where, sir, not simply where there is talk about facilitating the system, but where the delivery of justice, the delivery, sir, is facilitated in a timely manner. Sir, I would also need to say that, of course, there's also a need to look at other critical and important issues. I have said in this chamber before that I haven't done any social study. I'm not a criminologist, but I believe that it would be important to look at social factors, that it would be important to look at behavioral patterns. It would be important to look at the varying people who are engaging in crime, and if there are any commonalities with respect to those individuals. The point is that while we facilitate the proper functioning or the better functioning of our judiciary, we also have to ensure that we are able to provide support where there's deviant behavior and to assist those who may need help. Mr. President, sometimes we do have to help persons to protect themselves. So while I'm very supportive of this legislation, I also think that we do have to look at the broader issues as well associated with crime in Barbados. Mr. President, before I sit, I do want to make some reference to the section that is dealing with the divisions of the court. I believe it's at clause 3, which speaks to the 4 divisions of the court, the High Court, namely the Civil Division, the Criminal Division, Commercial Division, and the Family Division. And I specifically, Mr. President, want to make reference to the aspect about the Commercial Division. I believe that that division is very important. I believe, sir, that it is moving in the right direction. Sir, if you were to reflect on the Doing Business report of 2018, Barbados, sir, ranked 129 out of 190 economies and countries that were assessed. Sir, we have to look at that in the context of the fact that in 2013, Barbados ranked 88, so that there has been a significant decline. Sir, if we look at where some of our regional countries were identified in the Doing Business report, Jamaica was at 75, St. Lucia at 93, Trinidad and Tobago at 105. And reference, sir, in that report was made to legal rights in Barbados. And with respect to legal rights, Barbados scored 50%, 6 out of 12 possible points. And there are 2 areas, sir, that I want to reflect on quickly. The enforcement of contracts. In that report, Barbados ranked 170 out of 190. Sir, the report indicated that Barbados, out of a score of 100 in its overall performance with respect to the time that it took to enforce contracts, was at 38.02 out of 170 economies. Sir, that report as well also spoke to the quality of the judicial process. And it indicated that Barbados scored a 6.5 out of a possible 18. The expectation, therefore, is, Mr. President, that with the Commercial Division we will be able to see an improvement with respect to doing business in Barbados. And while we have so far in the debate focused on elements related to law in the context of civil and criminal, there's also the reference, sir, to commercial, which is very important and which allows Barbados to enhance its ability of doing business. Of course, that impacts overall as to how people view Barbados and impacts with respect to the investment in Barbados as a country, and also affects the concern that persons may have if there are any disputes that exist. So I think, sir, that this bill before this chamber is very important. I think it is a move in the right direction. Of course, as I have signaled, there is still additional work that needs to be undertaken, but this certainly is a bill that is moving in the right direction and providing for increase in the number of judges that we have, sir, and providing for a better execution in the justice. And therefore, with those few words on this occasion, sir, I completely support this bill. I thank you.
Thank you, Mr. President. Mr. President, I want you to have this opportunity to join my fellow senators in actually supporting this bill in relation to the increase in the complement of judges to the High Court. We have heard senators speak of, the semi-lawyers talking about justice delayed is justice denied. Now you have the other type of lawyer talking about other kinds of issues with delays. At the end of the day, though, it is true. Delays, as I believe it was Senator Greenwich who said, can be devastating. That is not in dispute. It is frustrating. It is devastating. It impacts people financially, mentally, physically, emotionally. It is really not a good thing. And to work in that system for as long as I've worked in the system, I have sadly seen it decline. What I'm concerned about this afternoon, though, is as we support the increase in the complement of judges, I don't know if it's just me being paranoid, but I'm getting the sense that delays are being solely associated with judges, which is not fair and it's not true. That is not what it is. I'm not saying that you may get frustrated by the way that a particular judge is doing something, but that cannot be what is being put out there, because that is not true. As Senator Greenwich said, we have bright judges. We have judges who, if they were given an opportunity, could appear even brighter, I would think. But we have come to a place where things have gotten so challenging for the judges. And I haven't been sent here to speak on behalf of anybody, but my remit is to look after the people of Barbados, which happens to be judges who, for some strange reason, are unable to defend themselves in any forum. So I am going to say it. We have judges now that, when I first started to practice, it was not an automatic requirement, as you would know, Mr. President, that when the case was finished, we had to prepare written submissions, because the judge had the information and the judge was in a position to quickly come to a decision or within a reasonable time. So it was not a requirement necessarily for you to produce written submissions of your case to assist the judge. Now we have to do written submissions, notwithstanding the fact that that judge may actually have a judicial assistant. And you do it because you recognize, pardon me, sir? I don't think it's a delaying tactic. I think it is because they recognize that their workload is such that they are unable to do the ideal thing that Senator Greenwich spoke about, which is as soon as they're finished, start to write. But if you have a week long if you do 2 or 3 matters in 1 week that went to trial start to finish, I don't think it is possible for you might be able to start 1, but not the 2nd or the 3rd. So that you still need to have the information at hand to help you remember, even as you took your longhand notes. Now, Mr. President, the written submissions will help you if when you are ready for them, they can be found. Because I am currently waiting on a matter, there's no fault of anyone, that it's just the way the system works. Because we have a situation where we have judges who will sit in a family matter. We get to the end of the trial, and then that judge is assigned to the assizes. Whereupon we have to wait for that judge to finish the assizes to be able to come back and address the family matter or the civil matter, and most importantly, deliver a decision. That is a delay. That is not the fault of a judge. It is the system. So that it cannot, I'm very conscious of, as an officer of the court, sitting in this august chamber and allowing it to be put out there that the judges are the problem. We have a building where it is not unusual to see a particular judge in a mask and his eyes blood red because the building is sick. I remember going to before that judge in the past, and I felt so concerned. I said a prayer. His eyes were bloodshot, and it's not unusual to see him with a mask on in that building. It's not unusual to have colleagues that come in speaking, and while they wait to go into court, they lose their voice. But my understanding is when that building was commissioned or taken over as the Supreme Court back in, was it 2009, Senator Boyce? Or thereabouts, there was sawdust everywhere. There was urine in bottles in places. It was never properly cleaned. And so it was downhill from there. I've heard of judges who did not know, because everybody looks for mold in the ceiling and on the wall. I have judges who didn't know they had mold on their chairs and on their furniture, but they're inhaling it every day. So there is a delay. But governments at large, and I'm not speaking on any particular administration, need to maintain their buildings and make sure that their buildings are not sick and make sure that people who are working and entering their buildings can function. If not, we're going to get delays. Because a sick judge means it's not a week and two adjournment in our world. Adjournments are 6 and 9 months, and God forbid, a judge starts your matter in the civil or family court and gets put into the assizes. You lock down. I've waited for decisions 2 and 3 years. And you have to tell clients these things, and they think that you're kidding. So it is not just the judges. Frankly, all of us in this system have been given a basket to carry water, frankly. Mr. President, have you ever been given a tour of the building? I have never gone into some of the rooms on the ground floor. The chairs and everything in that building are such that I remember saying to a judge one day, ma'am, we have the chairs, we have these film, the screen. The only thing missing is the popcorn, because the chairs are the chairs you find in a cinema. And you know, Mr. President, I am not bony. So when the chair, it is a challenge to sit. Delays happen for a number of reasons. We have a registry that is closing at 12 now instead of 3. What has been explained to us is because of the retrenchment, staffing issues. A 12 o'clock closing, shut down, that's not real for people who do.
Room.
Pardon me, sir?
Engine room not functioning?
Well, the engine, well put, sir. That's why you're the president. The engine room is not functioning. A registry closing at 12 in a work environment. Some people argue that it closing at 3 was too early, but it closed at 3. You can't do business. You can, financial business after 3. When you do something that closes it down at 12, whatever was not happening can happen even less. It is not feasible. So it is not the judges. There are delays. I am hopeful that this legislation, because it reads beautifully, the grand scheme of things, we are going to be saved, and all will be well, and we will be able to live again and have backlog cleared up and everything. If you do not give whoever you appoint the infrastructure and the administrative assistance to get this job done, this is just going to be rhetoric. Plain and simple. And on the question of rhetoric, the Constitution, as I believe Senator Boyce alluded to, Section 81 does, sir, speak to the Chief Justice and other judges of the Supreme Court shall be appointed by the Governor General by instrument under the public seal on the recommendation of the Prime Minister after consultation with the Leader of the Opposition. Recommendation and consultation here is different from what we understand it. I hope everybody understands that. So, as much as we have a Judicial Appointments Committee, I do hope that as the government continues to promote their transparency point that was well publicized and part of their manifesto and part of their agenda and part of everything read, I do hope that it is not just going to be lip service, and that those persons that are appointed with respect to the Judicial Appointments Committee will be persons chosen on merit, expertise, fairness, and integrity, and not partisan politics, sir. It would be a crying shame because it would make a joke of this legislation, saving it, that you're getting 5 judges. But then it will be loud, the same things that we're trying to avoid, as Senator McConney talked about. Questions and the talk that associated with some of the appointments. Don't mind Senator Greenwich quite rightly said that at this point, I don't think anyone who is a judge would be under attack in terms of the reason for their choice. We have sound judges who, when they get the opportunity to give you a decision, is something that you can keep, you can go on. We have some judges that you come to court with one thing and they get the opportunity to speak on that thing and other things. It becomes a precedent upon which you can rely and refer for future cases. I do hope that this Judicial Appointments Committee will be made up of persons like your goodly self, sir. I ain't saying that you to go on it because it will confuse the Senate, but persons who have what it takes to choose a judge, who have what it takes to make that type of decision for purposes of enhancing our judicial system, and not just party politics, paying back somebody because they did something or reviewed some piece of legislation or has been a long-standing member of a particular party for 100 years and therefore put them on the committee. And I noticed that the Prime Minister gets to determine the fees for this committee, and I expect that it probably will not fall into the usual realm of service to country where you get $150 for a meeting. I also noticed, Mr. President, in relation to the backlog, we're talking a lot about this backlog. And yes, we have a lot of cases. And yes, Senator Greenwich is right. Some of it is lawyers' fault. But some of it is also parties can't be found, or parties are overseas, or you're waiting on an expert witness and the expert witness is not available. That type of thing. But sir, what about mediation? We've been talking about mediation for the longest while, but you don't get the sense that it's going anywhere. We have people that are trained. We are hearing talk about core annex mediation. I would be bold to say, as someone trained in mediation, that some of the backlog can be addressed if we actually get serious about mediation and putting money behind the mediation. It will be cheaper to put money behind mediation than to have to outfit 5 more courts. A court means a judge, a legal clerk, a marshal, an orderly for that judge, an office, a secretary. A pardon? So how many people I just called? A judge, a legal assistant, a marshal, secretary, orderly, the space, and a car, Mr. President, and everything that comes with a judge. Mediation means let's just get it going. Come on. We've been talking about this since 2009. And every time certain people talk, we talk about it. And the justice impact, people give money and you get in training. And we're still the same place, more or less. I'm not saying that it's not functioning, but it should be functioning where it is now the norm rather than the exception. The Eastern Caribbean uses mediation as a matter of course. Trinidad uses mediation. There is actually a whole master's program at St. Augustine University. We in Barbados complaining about backlog. Help me to understand. We also have to do something with the files, that foreign party backlog, that are in the other place that you either can't find or nobody wants to touch, Mr. President, because they have on the mold that can kill you. What are we doing about those? If a client calls you and asks for a 1999 case, you got to take in a breath, sip of water and say, ma'am, sir, I will try my best. But if for me to ask for that file, I'm exposing somebody to whatever's going on in wherever they're being kept because it's sick. What are we doing about the sick? We are up at Manor Lodge and Cane Garden. So, what's happening down in Cane Garden is for criminal cases and some civil cases. The master is at Cane Garden as well. So, what do you do, Mr. President, with the files that are down in White Park that are sick? I understand that there was some cleaning, but I don't want to be responsible for exposing somebody to a sick file. But some of them form part of this backlog. We got some practice direction and some notification that we were supposed to notify the court which court cases we want to have addressed. That was for a moment, and then that petered out. The system needs to be reviewed, yes. It is not just the judges. And those who are running the system need the help. And where square pegs are in round holes, that needs to be addressed as well on a serious level. Because you can have the will in the world and you're at the top, but if the persons who are supposed to make it happen below you are not functioning, or they're in cliques, or they're sabotaging, you're still at square one, Mr. President. So hopefully, as the government moves ahead to appoint these 5 persons from any jurisdiction that when they're done got paid. I said it out loud? Proposition, I said it out loud. Okay. Look at it holistically. Don't dangle this in front lawyers who want to get the work done and then we go back to square one. Because I can't remember which person said, I think it was Senator Boyce. If we have 5 judges and everything underneath is not in place, we could as well have had 5 only. And it's not fair to the men and women who go every day in terrible conditions. Y'all don't even want to see Manor Lodge at 9:30 on the morning. It is a madness. Madness. And there's no aspersion on Manor Lodge owners. It is just that it is a complex that has other things going on. So it is really not ideal. It's the best you could have done. But the reality is it needs to be addressed sooner rather than later. And if we have a building that has lights on when it is empty, perhaps we need to be refocusing how we're spending money. Because I can never understand, if I'm in that area at night, why every light was on. I don't get it. Who's paying that? Why? What are we doing? And on the question of, well, let me don't go there. So if we're doing this, great. But it has to be a holistic thing. Senator Boyce talked about one step. But the reality is that you can't just appoint judges and don't have everything else in place, Mr. President. If not, we're just talking or appearing to be busy, but going nowhere fast, or as they would say, spinning top in mud. Mediation. Let's look at that. And let us deal with the delays. Mediation, get the judges. You have to give them an environment within which to work, Mr. President. It should not be that a judge and this other person is sharing a washroom and all this kind of thing going on right now. How are they functioning? And then on top of that, every once in a while, Senator Franklin says something that makes sense. You're not paying them enough for that? You can't disrespect the people like that. A car for somebody who has or who is not fascinated by having an orderly drive them, that doesn't impress them. But they have work to do. And let me say, I agree with Senator Greenidge. Two judges for family. People have to stop treating family like it is a joke area or a stepchild. If you have to give a decision in a family matter, you can more get away with giving points in a commercial matter than a family matter, because you have to explain to people why you have decided that your child cannot stay with you anymore. You cannot just say it is so. You have to explain it. You have to stop minimizing the family court. It is a critical component. Senator Greenidge came with numbers. You said 75%, Senator Greenidge. I think it is more. But it is an emotional area, and because of it, it calls for more explanation and more detail. I encourage those persons who have allocated 4 for commercial and 4 for civil, please for at least 1, maybe 2 for family. I don't agree with Senator Franklin that you need to be moving things from the Magistrates Court up to the High Court. We don't even get the ones for High Court done. Leave the magistrates. We have competent magistrates as well. And he is right. A lot of the matters the magistrates see first. So the magistrates need attention, and magistrates need help, and the magistrates need a bolstering of their infrastructure as well. But you have to give the family law court what they need. And we have to train people for family court mediation, which is different from court mediation. Because you have to train people in areas of security. I did training the other day, and we were told about a man who went to the bathroom, and the woman went to the bathroom, and the man went to the bathroom and killed the woman while she was in the bathroom. We need to be dealing, and these days you're getting killed about here, you know, mediation. People need to vent, people are angry. Family court needs more time. It is an emotional thing. Give people what they need to make this work. It really, really, government, look good on paper for truth. Look nice. So in that regard, I'm going to support it. Let's see what happens next. But hear me, I practicing as long as that little girl's been living. I'm just pointing. I'm pointing at you know, general area. I'm not senator. I am not speaking. I'm not speaking from lack of experience. What I'm speaking of is what I work. That's my area, and I encourage y'all. That's right. That's right. I encourage you to enhance the system. Let's move on from blaming, particularly unfairly, the judges. There are a lot of variables that inform a delay, and they all need to be addressed holistically for purposes of getting efficiency to be born through the system. I'm not going to stand out here and say the system is functioning properly, because it isn't. But it's not an easy fix, but it's not as easy as blaming an entity or a group of persons. It needs to be looked at holistically. And with those 2 words, Mr. President, I am obliged to you.
Thank you, Senator Tate. Ready, Senator McCartney, to make your concluding remarks?
President, thank you. I wish, Mr. President, to thank my colleagues for their contributions. I wish to thank Senator Franklin for his suggestions and his acknowledgement that the proposed system is far better than we had before. I wish to thank Senator Boyce for his suggestions on the tools to make implementation more effective, and his acknowledgement that the bill is one component of getting it right. I wish to thank and truly appreciate Senator Greenidge's insight on the significant social impact of justice delayed on the lives of families and individuals. I want to acknowledge Senator Grant's contribution on the potential of the commercial court to impact Barbados's record for ease of doing business. And I want to thank Senator Tate for recognizing and bringing to the attention that delays are caused by many factors that need to be addressed, and her call for alternative dispute resolution mechanisms to be utilized. This Supreme Court of Judicature Amendment Bill, Mr. President, is a concerted attempt by the Prime Minister, the Attorney General, and indeed the entire government to make the justice system work better for everyone. The judiciary is a key element of democratic government, along, of course, with the executive and the legislature. And when all of these work effectively, democracy is strengthened. And so, Mr. President, with these few words and with the optimism that we can continue to strengthen our democratic organs and arms of government, I beg to move that this bill be read a second time. I again beg.
The question is that the bill under consideration is now read a second time. All honorable members in favor, please say aye. Aye. Those against, please say no. I think the ayes have it.
Mr. President, I beg that you now leave the chair and that the Senate resolves itself into committee of the whole for the further consideration of this bill.
The question is that I do now leave the chair and the Senate resolve itself into a committee of the whole Senate for the further consideration of this bill in committee. All honorable members in favor, please say aye. Aye. Those against, please say no. We think the ayes have it, and we are now in committee.
The Senate is now in committee.
Mr. Chairman, I beg to move that Clause 1 stand part.
The question is that Clause 1 stand part. Honorable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 2. Mr. Chairman, I beg to move that Clause 2 stand part.
The question is that Clause 2 stand part. Honorable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 3. Mr. Chairman, I beg to move that Clause 3 stand part.
The question is that Clause 3 stand part. Honorable senators in favor, please say aye.
Aye.
Those against, please say no. Methinks the ayes have it.
Clause 4. Mr. Chairman, I beg to move that Clause 4 stand part.
The question is that Clause 4 stand part. Honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 5. Mr. Chairman, I beg to move that Clause 5 stand part.
The question is that Clause 5 stand part. Honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 6. Mr. Chairman, I beg to move that Clause 6 stand part.
The question is that Clause 6 stand part. Honorable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 7. Mr. Chairman, I beg to move that Clause 7 stand part.
The question is that Clause 7 stand part. Honorable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
The first schedule. Mr. Chairman, I beg to move that the first schedule be the first schedule to the bill.
The question is that the first schedule be the first schedule to the bill. Honorable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
The second schedule. Mr. Chairman, I beg to move that the second schedule be the second schedule to the bill.
The question is that the second schedule be the second schedule to the bill. Honorable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Report. Mr. Chairman, I beg to move that you now report to His Honor the President the passing of one bill in committee.
The question is that I do now report to His Honor the President the passing of one bill in committee. Honorable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I beg to move that this bill be now read a third time.
The question is that the bill under consideration be now read a third time. All honorable members in favor, please say aye. Aye. Those against, please say no. I think the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Supreme Court of Judicature Amendment Act 2019.
The question is that the bill do now pass and be so cited. All honorable members in favor, please say aye. Aye. Those against, please say no. I think the ayes have it. The bill is now being passed and will be so cited.
Order number one, Mr. President, in the name of the Honorable Leader of the Senate, to move the passing of a resolution to approve, in accordance with Section 5 of the Land Acquisition Act, Chapter 228, the compulsory acquisition by the Crown of the parcels of land situated at Spikestown in the parish of St. Peter in this island for the public purpose, namely to facilitate the Salt Pond Drainage Improvement Phase 2 project.
Mr. President, I rise to speak on the resolution before this honorable chamber that seeks permission for the compulsory acquisition of 8 parcels of land situated in an area of Spikestown known as Round the Town, which is in a central part of the town of Spikestown in the north. This acquisition is necessary to mitigate in the flooding in the mitigation project for the Salt Pond Drainage Improvement Project Phase 2. Now, as you know, many parts of the many parts of the northern part of the island has extensive flooding, and Spikestown is one such area. I think most members present will recall that just a few months ago last year, when there was some very heavy rainfall, Spikestown was one of the areas that was greatly affected, so much so that parts of the same area, there were large torrents of water coming through what would have been the culvert at the end of Queen Street, right before you get to an area that people know as Fisherman's Pub. And it looked just like if you were in a river with rapids. That's how severe the water that came from a higher elevation would have been in the area. And you'd also recall that the road was impassable, the main road of Spikestown, in the vicinity of the gas station and a very popular local restaurant, where it did take heavy equipment from the Ministry of Transport and Works in order to remove the debris that stopped people from being able to pass and go about their daily business. And that was just with some extremely heavy rainfall. So one would understand that with a more severe weather condition, what could result in the area of Spikestown. Now, as we know, Spikestown has, in recent times, become a heavily used tourism area, with many establishments having been placed there within the last couple of years. There's several very popular restaurants. They have some beach facilities. They have the 2 upmarket and upscale projects to the lower part of Spikestown, both built around marinas. And so one certainly would want to control the level of flooding that currently pertains in Spikestown, both for the locals as well as for the tourists who have now become a central part of that northern part of our country. So a pilot project was carried out a little further upstream in a drainage system around an area known as the Salt Pond, in order to see and to find out what was necessary to be able to control what was happening further downstream. And coming out of that project, it was adjudged that there was a necessity to acquire these parcels of land in order to expand the drainage network in Speightstown. And this is being facilitated as part of an overall project which would have been agreed upon in 2017 with the BTII board through a loan agreement with the Caribbean Development Bank for this, what was known as the Speightstown Road Mitigation Project, which coincidentally, Mr. President, would have started back in 2014. So the consultants and the other individuals who have been working on this project need to commence work in a culvert in the same around the town area that would be expanded to help to mitigate this flooding. And in order to commence this work, it has become necessary to acquire these 8 parcels of land that are not owned by the Crown to accommodate the widening of this channel. So notices were already published in accordance with the Land Acquisition Act Cap 228, and authorizations under Section 4 of the same act have been duly executed, Mr. President. And these 8 parcels of land to be acquired contain about 86.4 square meters in road reserve and total land area of 3,599.1 square meters of land. So, Mr. President, based on information received from the Chief Surveyor on the details of the parcels of land have been certified, and an opinion of the value of each parcel has been adjudged. And with this here, we are now asking that this land be acquired, and I'm at this point asking that this resolution do now pass.
Yes, Senator Miller, I'm sorry. Yes,
President.
Please proceed, yes.
I rise to venture into the area outside of my specialty, but I think it is necessary. I am pleased that following from last week's extensive discussions with the new town planning or planning bill, or act rather, that we have fallen on with an appropriate piece of legislation. Flooding all over Barbados has become a major problem, not just in Speightstown. There are roads that were previously passable that are now not passable when a visitor spits on the side of the road. And it is because of development. And sometimes it's development that did not bear consideration for what happens to the unpredictable rains. And we have seen it in Holders Hill. We have seen it in 1995, and unfortunately, it caused the death of someone. And while I do not recall anyone yet dying in Speightstown, I'm glad that this government will move to take measures before it happens. But I also think that the measures which Senator Moore spoke of that were looked into further upstream to deal with the sources of the water and to control it are very important. We cannot expect to deal with the water that comes downhill at the points where it exits into the sea. We have to probably control it much further up in its course. Now, We've seen the beautiful work done in Bridgetown on the Constitution River. And there's a little park next to Central Bank called, I think it's called the Village Green, that most people will not have visited, and I encourage you to visit it. It is probably the most beautiful park in Barbados. And there's a huge drain going through it. The Village Green is next to the Central Bank. Beautiful piece of landscaping. It's next to the Central Bank. It's where I think Church Village was once located. Lots of money spent, and I think it's a beautiful city park. And I hope that when the works are completed on the salt pond, we will not only have a big drain and culvert that water can pass through, but one that is aesthetically in keeping with some of the things we spoke of last week, where some person will be able to sit at a bench in safety and enjoy a drink either in the morning, evening, or in the night. Because we need to be constantly thinking that these improvements can't only be about the problems that we're solving, but be about the future. And we have to protect our future, which is probably more often vested in those who are unborn and are being born as we speak. We have to allow development that does not harm people. And Mr. President, we left this chamber on Wednesday, and as I drove down the Royal Map Highway on Thursday, I couldn't help but notice a hoarding going up on the western side of the road. And over the last few days, an open area has been enclosed. And I would like to believe that the appearance of heavy equipment on the site would suggest that there is going to be new construction of some type of facility in the center of what is a residential area, on the edge of it. That site, if we ever were going to have a green open site in Warrens, that should have been it. And it makes me wonder whether we are serious about what we are doing now, what we will do in the future, and what we've done in the past. And yes, I'm being critical. I think about what happened to the poor child who died in Christchurch when it was an accident. And I wonder whether we might well be creating the same type of situation again. And if enough thought has gone in to approving what is about to happen. And I hope, Mr. President, that my concerns are unfounded, and in my lifetime, and all of ours, that it will never happen. And I hope those who are listening will make sure that the obstructions and the dangers that were created that might have caused the death of a child will not happen at that new site. Mr. President, I'm obliged to you.
Senator Grant?
Mr. President, I don't intend to delay this chamber. Of course, this resolution is very important to deal with the issue of drainage. The acting leader of government business has properly identified the reasons for this resolution. Of course, we also have to look at the issue as it relates to the reason that causes some of the drainage problems. And sometimes there's the improper disposal of garbage. There's illegal dumping as well. And from that perspective, sir, I just wanted to crave your indulgence to speak very briefly to some refuse collection issues. Of course, it would impact on the Speightstown area. because if you don't have the proper collection of garbage, if you have illegal disposal of garbage, there would be an impact there. I am aware, sir, that recently there were some comments which would have suggested that the Sanitation Service Authority is not operating on weekends, and that may be a cause as to why there is garbage seen on the streets. Let me make this point, sir, that the Sanitation Service Authority collects garbage every single day. That is a responsibility. But I believe, sir, that it was Senator Greenidge in a previous debate who said that his mother often made a reference that you cannot get a gallon out of a Jill Tartan. The reality is that the Sanitation Service Authority operates with about 15 trucks a day, when 34 trucks are needed. And I felt, sir, that it was very important that I highlight that point. I also would like, sir, for persons to know that there's a SSA hotline, if you call that hotline. So the people of Spikestown, sir, whether they're in Church Street, Gills Street, whether they're around the town in Spikestown, sir, that persons in Spikestown or wider Barbados can call 535-5006. 535-5006, sir, to speak to the SSA hotline individual between 8:15 a.m. and 4:30 p.m., sir, to be able to communicate any issues, sir, with respect to refuse collection. I also want to just briefly indicate, Mr. President, that as chairman of the SSA, I will be meeting tomorrow with the manager and the deputy manager operations, along with all of the supervisors and superintendents, to look at the issue of refuse collection and to assure the public that it is a matter that is being given our very serious attention. Encourage them again to use the hotline, but to give the assurance that we will do our very best. But at the end of the day, we must say that you cannot get a gallon out of a Jill Tartan. I'm obliged to you, sir.
Mr. President, I do want to thank all of my colleagues for their contributions, but I just would like to reiterate that the Ministry of Transport and Works has determined that the culverts under the Spikestown bypass will continue to adversely affect and impact flooding upstream. Therefore, it would require an improved drainage area under the Spikestown bypass. I would also like to just say that this project is not a sudden project. This project has projections on a 1 in 10 to 15 year storm projection. And the proposed drainage improvements are inclusive of the retention of a storage scheme proposed on the main tributary upstream as well, Mr. President. But a drainage system is not just one area, it is several areas from upstream to downstream. And without all of the improvements along the way, what then ends up happening is that there is not full capacity for the system to operate and function efficiently. And we recognize that based on what has been occurring and based on the study. This is an ongoing study where they have a project that allows them to carry out upstream drainage system discharging through the salt pond as a step in the process to consideration of the retention of the storage facilities in the upstream area. So I just want to say that this is not a sudden project. This is something that would have been ongoing now for since 2014. So this is going on 5 years. 5 years. This has been since October 2014, and so it's been ongoing for quite some time. It was first approved and considered way back in January of 2014. And so just to say that it's critical to the mitigation of flooding within the catchment area that we ensure, Mr. President, that this land is acquired from the landowners, and of course they will not be disadvantaged. but because it is as you know, that area of Spicestone is a mixed-use district. But it is absolutely necessary that these lands be acquired as part of this drainage project. And so with these few remarks, Mr. President, I beg that this resolution do now pass.
Question is that the resolution before the Senate approve. Mr. Clark, the issue is whether the resolution be now pass or approve. I think the language is approve. So I'll put the question afresh. That the question is that the compulsory resolution relating to land at St. Peter under consideration be now approved. All honorable members in favor, please say aye.
Aye.
Those against, please say no. I think the resolution is now passed.
Minutes recommitted, sir.
Yes, there are two sets of minutes. There's the minutes relating to the 23rd of January, 2019. I think we are now seeking confirmation of those minutes. So the question is that the minutes of the 23rd of January this year be now confirmed.
Mr. President, I move that the minutes of January 23rd be approved.
I think we need to confirm first.
Oh, sorry, be confirmed.
Yes. The question is that the minutes of the Senate for the 23rd of January this year be now confirmed. All honorable members in favor, please say aye. Aye. Those against, please say no. I think the ayes have it, and the minutes are now confirmed for the 23rd of January. There's also the minutes for the 30th of January.
Mr. President, I would like to move that the minutes of January 30th be deferred.
Question is that the minutes of January 30th be now deferred. All honorable members in favor, please say aye. Those against, please say no. I think the ayes have it, and the minutes are now for the 30th of January are now deferred.
Mr. President, that now concludes the business of government for today. And I would like to thank all senators for their contributions today. And on behalf of my colleagues, I know we would want to wish our fellow senator, Senator Tate, a happy birthday. Today is her birthday. I would like to wish her a happy birthday. And now I would like to, Mr. President, beg to move that the Senate do now be adjourned sine die.
Well, I join in congratulating Senator Tate on her birthday. I hope it continues to be a happy day for you.
Thank you very much, Mr. President, and all other senators.
And my deputy is urging me to wish you a happier night. And I am happy to so do. While putting the question before us, that is that the Senate be now adjourned without the day appointed. All honorable members in favor, please say aye. Aye. Those against, please say no. We are now adjourned sine die without the day appointed.